Will the House please come to order and members kindly take their seats? This afternoon's devotional will be led by the Reverend Devin Thomas of the Second Congregational Church in Hyde Park.
And so, sisters and brothers, if you will please join me in a moment of contemplation and or prayer. May a spirit of love, compassion, and service bless you, the members of this legislative body, as you come together to do the work of your constituents and do the work of this state. May your individual gifts and insights serve as a blessing, both to those that you serve and to all who rely upon you here in Vermont. May you be a support to those who struggle, offering relief to the sick, offering salvation to those who have been left behind and left unheard. May you serve as a blessing of love, so that those who are last may be put first, and that you may be a continually present force for good. May your ability to work together, to address the different challenges of this day and age, be used in a way that overcomes the adversity that often faces us in this day and age. May you be able to hear the voices of those who struggle with inequality due to housing, due to education, due to equity in many shapes and forms. Sisters and brothers, you have a power to be a force for good within this world. And may your commitment to see love shine in this world be both a blessing to you, those who rely upon you, and those who look to you for guidance. May that light of peace shine bright in your hearts. Amen. Thank you.
Members, we have 14 bills for introduction this afternoon. House Bill 146 is an act relating to amendments to the Charter of the Northeast Kingdom Waste Management District, introduced by Representative Sims of Craftsbury and others. Please listen to the first reading of the bill.
H 146, an act relating to amendments to the Charter of the Northeast Kingdom Waste Management District.
Now the bill has been read a first time and is referred to the Committee on Government Operations and Military Affairs. House Bill 147 is an act relating to the creation of the Vermont State Building Security Board, introduced by Representative Carl Demeraux of Corinth and others. Please listen to the first reading of the bill.
H 147, an act relating to the creation of the Vermont State Building Security Board.
Now the bill has been read a first time and is referred to the Committee on Corrections and Institutions. House Bill 148 is an act relating to raising the age of eligibility to marry, introduced by Representative Odie of Burlington and others. Please listen to the first reading of the bill.
H 148, an act relating to raising the age of eligibility to marry.
Now the bill has been read the first time and is referred to the Committee on Judiciary. House Bill 149 is an act relating to write-in candidate consent of candidate filings in state elections, introduced by Representative Brennan of Colchester and others. Please listen to the first reading of the bill.
H 149, an act relating to write-in candidate consent of candidate filings in state elections.
Now the bill has been read the first time and is referred to the Committee on Government Operations and Military Affairs. House Bill 150 is an act relating to the approval of an amendment to the Charter of the Village of Alburgh, introduced by Representatives Levitt of Grand Isle and Morgan of Milton. Please listen to the first reading of the bill.
H 150, an act relating to approval of an amendment to the Charter of the Village of Alburgh.
Now the bill has been read a first time and is referred to the Committee on Government Operations and Military Affairs. House Bill 151 is an act relating to petitions for guardianship of individuals with developmental disabilities, introduced by Representative Bromstead of Shelburne and Wood of Waterbury. Please listen to the first reading of the bill.
H-151, an act relating to petitions for guardianship of individuals with developmental disabilities.
Now the bill has been read a first time and is referred to the Committee on Human Services. House Bill 152 is an act relating to regulating products containing certain chemicals and chemical classes, introduced by Representative Dolan of Waitsfield and others. Please listen to the first reading of the bill.
H-152, an act relating to regulating products containing certain chemicals and chemical classes.
Now the bill has been read a first time and is referred to the Committee on Human Services. House Bill 153 is an act relating to Vermont tax incentives, introduced by Representative Canfield of Fairhaven. Please listen to the first reading of the bill.
H-153, an act relating to Vermont tax incentives.
Now the bill has been read a first time and is referred to the Committee on Ways and Means. House Bill 154 is an act relating to Medicaid coverage for doula services, introduced by Representative Coffey of Guilford and others. Please listen to the first reading of the bill.
H-154, an act relating to Medicaid coverage for doula services.
Now the bill has been read a first time and is referred to the Committee on Health Care. House Bill 155 is an act relating to mileage reimbursement rates for plug-in electric vehicles, introduced by Representatives William of Berry City and others. Please listen to the first reading of the bill.
H-155, an act relating to mileage reimbursement rates for plug-in electric vehicles.
Now the bill has been read a first time and is referred to the Committee on Government Operations and Military Affairs. House Bill 156 is an act relating to incremental implementation of Green Mountain Care, introduced by Representative Chena of Burlington and others. Please listen to the first reading of the bill.
H-156, an act relating to incremental implementation of Green Mountain Care.
Now the bill has been read a first time and is referred to the Committee on Health Care. House Bill 157 is an act relating to the Vermont Basic Needs Budget, introduced by Representatives Blumley of Burlington and Stevens of Waterbury. Please listen to the first reading of the bill.
H-157, an act relating to the Vermont Basic Needs Budget.
Now the bill has been read a first time and is referred to the Committee on General and Housing. House Bill 158 is an act relating to the Beverage Container Redemption System, introduced by Representative Sheldon of Middlebury and others. Please listen to the first reading of the bill.
H-158, an act relating to the Beverage Container Redemption System.
Now the bill has been read a first time and is referred to the Committee on Environment and Energy. And finally, House Bill 159 is an act relating to the Vermont Broadband Internet Access Service Privacy Act, introduced by Representative Sibilia of Dover. Please listen to the first reading of the bill.
H-159, an act relating to the Vermont Broadband Internet Access Service Privacy Act.
Now the bill has been read a first time and is referred to the Committee on Commerce and Economic Development. Members, we have a bill on the notice calendar for referral to a money committee pursuant to House Rule 35A. House Bill 46 is an act relating to the approval of the dissolution of the Colchester Fire District Number 3, materially affecting the revenues of one or more municipalities. The bill is referred to the Committee on Ways and Means. We now have a joint Senate resolution to take up at this time. JRS 12 is a joint resolution relating to weekend adjournment, offered by Senator Baruth. Please listen to the reading of the resolution.
JRS 12, Joint Resolution Relating to Weekend Adjournment. Resolved by the Senate and House of Representatives that when the two houses adjourn on Friday, February 3rd, 2023, it be to meet again no later than Tuesday, February 7th, 2023.
Now you've heard the reading of the resolution, and the question is, shall the House adopt the resolution in concurrence? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and the resolution is adopted in concurrence. Members, we've received a request to read a House concurrent resolution that the House and Senate adopted pursuant to the consent calendar. HCR 16 is a House concurrent resolution celebrating the importance of mentoring programs for young persons in Vermont. Please listen to the reading of the resolution.
Whereas the future of Vermont rests on the hopes and dreams of its young people, and whereas caring and committed mentors offer support for youth when they act as a consistent friend and role model, help to ignite a young person's curiosities, solidify a youth's passions, and encourage the flowering of an individual's potential. And whereas mentored youths exhibit improved resiliency and better relationships with peers, family, schools, and community. And whereas Vermont mentoring agencies, including Vermont Mentor and other public and private organizations, are committed to working collaboratively to empower youth and broaden the reach of mentoring relationships in our communities. And whereas in January 2002, Mentor, the National Mentoring Partnership and Harvard University's T.H. Chan School of Public Health jointly designated January as National Mentoring Month. And whereas today, February 1st, 2023, Mentor Vermont, which is committed to fostering an environment of diversity and inclusion, is extending Mentoring Month 2023 by 1 day for a special legislative commemoration of this creative and invaluable movement to assist young persons in their quest to develop meaningful lives. Now therefore be it resolved by the Senate and House of Representatives that the General Assembly celebrates the importance of mentoring programs for young persons in Vermont, and be it further resolved that the Secretary of State be directed to send a copy of this resolution to Mentor Vermont.
Are there any announcements? Member from Georgia.
Thanks, Madam Speaker. I've never used this microphone before, so tell me if you can't hear me. It's my pleasure to introduce this afternoon Reverend Devin Thomas from the town of Georgia, my hometown. He pastors the Second Congregational Church over in Hyde Park, and he's taken time this afternoon to spend with us, and he also spoke to the State Senate earlier today. So I'm very pleased to have him here, and I hope that you will help me welcome him.
Will the guest and the member from Georgia please rise and be recognized? Member from Essex.
Thank you, Madam Speaker. I have a very special guest in the gallery today. Faith Scarrett, a brilliant UVM student majoring in political science and health and society, is joining us today. Faith is from New York City and has made Vermont her home for the last 3 years and is in her junior year at UVM. Representative Dodge and I are fortunate to have Faith support our work as an intern this semester. Please welcome her to the People's House.
Will the guest and member from Essex please rise and be recognized? Member from Wolcott.
Thank you, Madam Speaker. Please join me in welcoming the CEOs, medical directors, chief financial officers from Vermont's federally qualified health centers. These primary care providers serve Vermont around the state, regardless of their ability to pay. They care for more than 2/3 of our uninsured and more than 1 in 3 Vermonters who are on Medicaid. The FQHCs provide comprehensive services that include primary care, mental health, substance use disorder treatment, and dental services. These providers before and during the pandemic step up every day to meet the needs of their communities and are on the front lines of our healthcare system to meeting Vermonters where they are. Notably, every FQHC in Vermont provides medical assisted treatment services. All have achieved Blueprint patient-centered medical home status. Please join me in expressing appreciation for their commitment to Vermonters. The health center representatives here today are Northern County Health Centers, Lamoille Health Partners, Little River Healthcare, Community Health Centers, Community Health, and Gifford Medical Care. Thank you.
Will the guest and the member from Wolcott please rise and be recognized? Member from Craftsbury.
Madam Speaker, the Rural Caucus will have its regular Thursday meeting tomorrow at 8. We'll be back in the pavilion in our regular room 207 and online. We'll be talking about updates on our rural omnibus bill, a new omnibus recreation bill, hearing from members about bills in their committee, and looking ahead to decide on our future meeting topics. Hope to see you there.
Member from Berkshire.
Thank you, Madam Speaker. Please join me in welcoming 2 UVM legislative interns who are working to support the Republican caucus. Their names are Olivia Colavita and Charlotte Mays, and they are seated in the balcony.
For the guests and the member from Berkshire, please rise and be recognized. Member from Williston.
Thank you, Madam Speaker. We just heard a resolution honoring the importance of mentoring programs for young persons in Vermont, and I'm proud to carry on the tradition of the former member from Shelburne in recognizing this important work. Vermont mentoring agencies, including Mentor VT, play a critical role in empowering youth through support and resources. Their vision is for every young person in Vermont to find the supportive, mentoring relationships they need to grow and thrive in our communities, and these relationships can truly be life-changing. The resolution we heard began, whereas the future of Vermont rests on the hopes and dreams of its young people, and that certainly captures why I serve in this body. I'd like to thank Mentor VT, their partner organizations, and most importantly, the mentors and students who are with us today, although many of them unfortunately had to leave before our floor session began. Please join me in honoring these guests.
For the guest and member from Williston, please rise and be recognized. Member from Rutland City.
Thank you, Madam Speaker. The VSCA will have its dinner tonight at its VSCA headquarters on Main Street. The topic for tonight is going to be safety and security. And the dinner will begin at 5:45 p.m. We hope that you will join us for an evening of good food catered by Morse Block Catering, and lively conversation. Everyone is welcome. Thank you.
Member from South Burlington.
Madam Speaker, I would like to let the members know that the Vermont chapter of the Alzheimer's Association is hosting a coffee and breakfast bar in the cafeteria tomorrow morning from 8 to 9:30. This will be a great opportunity to talk to some Vermonters who have been touched by dementia and to learn more about the work of the Alzheimer's Association in Vermont. And you can show your support for Vermonters with Alzheimer's and their family caregivers by wearing purple tomorrow. Thank you.
Member from Guilford.
Madam Speaker, it's Wednesday today, and tonight we are really excited to have the Vermont Symphony Orchestra for Vermont Farmers Night. Tonight, Dr. Yukata Kono, who's the director of the orchestra and associate professor of music at the University of Vermont, her music will be performed this evening. So this is a really popular concert, so I encourage you to come, and I encourage you to, if you want to sit at your seat, perhaps do what I have done, which is scribble out a little reserve sign. So anyway, we look forward to seeing you tonight, and we the month will continue with some really wonderful concerts and events. So thanks. Hope to see you. 7:30 tonight.
Are there any further announcements? Member from Burlington.
Thank you, Madam Speaker. A reminder that tomorrow at noon in the pavilion, room 267, is the Climate Solutions Caucus. We will have a brief overview of the Transportation Affordability Act and an overall summary, very brief, in terms of where we're at and what we've done and what we haven't with regards to energy, and then updates regarding climate change related bills from every committee. Pizza, thanks.
Are there any further announcements? Member from Poultney.
Madam Speaker, the last in a series of the administration's briefings will take place today in the Pavilion Auditorium between 4:15 and 5:15 p.m. Tonight's topic is broadband.
Are there any further announcements? Seeing none, orders of the day. On our action calendar today is House Bill 45, which is an act relating to abusive litigation filed against survivors of domestic abuse, stalking, or sexual assault. The bill was referred to the Committee on Judiciary, which recommends that the bill be amended as printed in today's calendar. The member from Burlington, Representative Rachelson, will report for the committee. Please listen to the second reading of the bill.
H45, an act relating to abusive litigation filed against survivors of domestic abuse, stalking, or sexual assault.
Member from Burlington.
Thank you, Madam Speaker. I too am using the microphone for the first time, so let me know if it's okay. Imagine for a moment that you have been in an abusive relationship, sexually abused, or stalked. All of these are terrifying situations. Finally, you think the nightmare will end after you leave the relationship or watch the person who assaulted or stalked you get charged and sentenced, only to learn that the abuser has found a new way to continue to engage with you, and there is no end in sight to this stopping. Ooh, okay. Tragically, so many people face the fallout that occurs after they have been a victim of domestic violence, sexual abuse, or stalking. While each of these cases is unique, they share the dynamic of someone exercising power and control inappropriately over others. Court proceedings are one vehicle an abuser can use to try and reestablish power and control over a survivor even long after a relationship has ended. I and many of our committee members were surprised to learn about the ways that these types of abuse continue to play out through a process known as abusive litigation. We heard from one victim directly, and nothing can describe the desperation, fear, and terror that this victim has lived with every day and has little to no hope that it will ever change. What is abusive litigation? The term abusive litigation includes the misuse of court proceedings by abusers to control, harass, intimidate, coerce, and/or impoverish survivors. While the practice is common, it does not have a generally recognized name. It has also been described as legal bullying, stalking by way of the courts, paper abuse, vexatious litigation, and similar terms. Why do abusers use abusive litigation? Litigation is a way that abusers can attempt to reestablish and retain control over a survivor, particularly when other forms of contact with the survivor have been restricted. The need to reassert control after the survivor physically separates from the batterer manifests itself in litigation tactics that are designed to overwhelm the survivor's life. So what does abusive litigation look like? Abusive litigation can occur in many different courts. Abusive partners will bring repeated motions against survivors, often with no factual or legal basis, to file claims on matters that have been previously been settled by the court, or seek to bring legal motions in various jurisdictions after receiving unfavorable rulings. Frequently, abusive partners will represent themselves or be pro se in these legal matters. Lawsuits can even be filed from prison. So why do we need H45? Abusive litigation often follows a survivor's decision to leave or separate, file for divorce or for a protection order, report physical abuse, or call police for assistance. Litigation is providing a means for the abuser to assert power and control over the survivor. The research shows misuse of the court process often goes unchecked and unpunished. Current remedies have been found to be inadequate, inaccessible to many litigants, and inconsistently applied. And the ramifications and toll these tactics take are significant. The trauma victims experience would be enough of a reason for this body to act. Unfortunately, abusive litigation does much more than just causing significant and long-term harm to survivors and their families. In addition to the stress incurred from this experience, here are 3 more reasons. 1, abusive litigation can drain victims' finances, causing them to miss work, pull them away from their families, and force them to navigate the complex legal system, often on their own, or repeatedly hire lawyers that further drain victims' financial resources. Even if a lawsuit is meritless, because the legal stakes are high, Survivors almost always need to access legal representation at significant financial cost. We heard from a Vermonter who had to sell her house to pay for the legal fees, which has been going on for over 5 years. Missing work for court hearings puts victims at risk of losing their jobs and certainly loss of income from missing work. 2, the legal system that a survivor believed would provide protection becomes another weapon that an abuser can use to cause harm and devastation. In addition to the abuser finding a new avenue for harassment, the abuser is also telling the victim that the court isn't a safe place for them. Abusive litigation has victims living in fear that the very courts designed to protect them now force them to spend time with their abuser. And 3, really importantly as well, abusive litigation is also a waste of public resources and diminishes trust in the court system. Right now, our court resources are more precious than ever before. Vermonters are waiting months for their day in court. Wasting these resources costs taxpayer money and delays serving justice to people waiting for their court date. The bill before us is a very measured and careful way to deter baseless filings in order to curb the ability of abusers to use the justice system to continue to abuse their victims and inappropriately use the judicial system. So I keep getting asked, why can't the judge just stop this? Why do we need a bill? Historically, judges have had some power to fight back against vexatious litigation. Judges in Vermont have some discretionary authority to control the conduct of litigants through Vermont's court rules, Rule number 11. However, we learned through testimony and current practice that Rule 11 isn't adequate to address this detrimental problem. H45 provides the courts and victims with an additional tool to curb abusive litigation and to mitigate the harms abusive litigation perpetuates. We heard in testimony that other states have this problem as well, and 2 states have passed laws to address the issue. The original version of H45 is based on a proven approach utilizing the successful statutory frameworks in the model laws that were passed and successfully implemented in the states of Washington and Tennessee. Through extensive testimony on H45 and input from many people, I'll give you the full list later, but including the Chief Superior Judge, the Attorney General, Vermont Legal Aid, the Vermont Network, our committee crafted a strike-all amendment to incorporate this feedback and further improve the bill before you. What does H45 propose to do? This bill would establish a narrowly defined process to protect victims and the courts from abusive litigation and still protect the due process rights of those using abusive tactics. We all in our committee take these due process rights very seriously, and in the interest of justice and constitutional rights, our committee is bringing forth to you a bill that accomplishes this balance. This bill would give victims in the courts the additional tools for protection. It will allow the court to screen legal filings to protect both the well-being of the survivor and the resources of the court. And very importantly, H45 includes several safeguards designed to ensure that the proposed statute isn't in turn weaponized against survivors of domestic violence. This includes a 2-part eligibility test, which first establishes that a plaintiff has been a victim of domestic violence, sexual assault, or stalking, and that their former partner has used abusive litigation tactics. The bill before you is very narrow and only applies to someone who has been abused a victim through domestic violence, sexual assault, or stalking. So if you look on page 27 of today's calendar, you can follow along with me. This H45, the strike-all amendment that appears in here, creates a new subchapter within our abuse prevention chapter to establish a procedure to allow survivors of abuse to request a court to issue an order restricting the abuser's ability to file new litigation against the survivor. The first section of the bill, sections 1181, are the definitions. And those include the parties that are eligible, what household members are, and I'm happy to go into greater detail, but I will let people look at the definitions. It also includes the definition of what we are calling abusive litigation. The second section of the bill, section 1182 and 1183, entitled Order Restricting Abusive Litigation, Hearing and Procedure, sets forth the procedure for requesting an order restricting abusive litigation. If the factors considered as to whether there is a rebuttable presumption that the litigation is being filed for purposes of harassing the survivor. For the sake of knowing what a rebuttable presumption is, a rebuttable presumption means that something may be inferred from the existence of a given set of facts and that it is conclusive absent contrary evidence. So this would also make sure that the same or substantially similar issues between the same or substantially similar parties have been litigated within the past 5 years, or the same or substantially similar issues between the same or substantially similar parties have been raised, pled, or alleged in the past 5 years and were decided on the merits or dismissed. Or within the last 10 years, the party allegedly engaging in abusive litigation has been sanctioned by any court for filing one or more cases, petitions, motions, or other filings that were found to have been frivolous, vexatious, intransigent, or brought in bad faith involving the same opposing party. Or any court has determined that the party allegedly engaging in abusive litigation has previously engaged in abusive litigation or similar conduct and has been subject to a court order imposing pre-filing restrictions. In the next section is the burden of proof, which in this case, the standard is preponderance of the evidence. And after providing the parties an opportunity to be heard, the court may enter an order restricting abusive litigation that may include conditions deemed necessary and appropriate. And those can include awarding the other party reasonable attorney fees and costs of responding to the abusive litigation, including the cost of seeking the order restricting abusive litigation, and identifying the party protected by the order and imposing pre-filing restrictions upon the party found to have engaged in abusive litigation that pertains to any future litigation against the protected party or the protected party's defendants. The next section spells out how the person who is being restricted would be able to file a new case in order to still have their due process rights. So a person who is subject to an order restricting abusive litigation is prohibited from filing, initiating, advancing, or continuing the litigation against the protected party for the period of time that the filing restrictions are in effect. The person who is subject to an order restricting litigation against whom pre-filing restrictions have been imposed, who wishes to initiate a new case or file a motion in an existing case during the time the person is under filing restrictions, shall make an application to a judicial officer. So they still have their option to have their day in court. The judicial officer will review that application and determine whether the proposed litigation is abusive litigation or if there are reasonable and legitimate grounds upon which the litigation is based. If the court determines the proposed litigation is abusive, it is not necessary for the person protected by the order to appear or participate in any way. If the judicial officer is unable to determine whether the proposed litigation is abusive without hearing from the person protected by the order, then the court shall issue an order scheduling a hearing and notifying the protected party of the party's right to appear or participate. And whenever possible, the protected party shall be permitted to appear remotely. If the judicial officer believes the litigation the party who is subject to the pre-filing order is making application to file will constitute abusive litigation, the application will be denied, dismissed, or otherwise disposed of with prejudice. If the judicial officer believes that the litigation the party who is subject to the pre-filing order is making application to file will not be abusive litigation, the judicial officer may grant the application and issue an order permitting the filing of the case. The judicial officer shall make findings and issue a written order supporting the ruling. If the party who is subject to the order disputes the finding of the judge, the party may seek review of the decision as provided by the applicable court rules. And the last section is the effective date. The act shall take effect as of September 1st, 2023. And the vote in our committee was a resounding 11-0 in favor of the bill. The witnesses we heard from include an impacted Vermont citizen, Vermont Legal Aid, our legislative counsel, the Attorney General, the co-director of Community Justice Division in the Attorney General's office, the Deputy Director of the Vermont Network Against Domestic and Sexual Violence, and our Chief Superior Judge. Our committee members felt we are building stronger guardrails and recognize that in the last 10 years, we have made access to the court easier to access for pro se plaintiffs, which is a good thing, but it is likely resulting in more frivolous lawsuits. While Rule 11 allows court to sanction frivolous lawsuits, this bill is sorely needed to give judges the policy change and tools needed to adequately address this problem. This bill strikes a good balance and is sufficiently precise. It adequately protects survivors, and it protects the judicial system from being used for nefarious purposes while still protecting a litigant's constitutional right to court access and the ability to protect the court's resources from abusive litigation. Madam Speaker, we strongly urge this body to vote yes for the passage of H45.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? Member from Northfield.
Thank you, Madam Speaker. I think this is well thought out and strong bill. I rise in support. I'm particularly impressed by the care and balancing that it takes for rights and protections of the parties. I do have a couple of technical questions or clarifications, if I might interrogate the member from Burlington.
The member from Burlington is interrogated.
Madam Speaker, first, in terms of the definition, I note the under 1A, small I, the reference to a current or former family or household member, which could be a little vague. I know that in other parts of statute, we have a very specific definitions of who constitutes a, quote, family member to help make it explicit. So I was wondering, are those definitions something that are already within this chapter of law, or is this something where it should be cross-referenced to, we typically see the phrase as defined in with the section of law that gives the fuller definition?
So, Madam Speaker, my apologies for not going over the definition section. I skimmed over that part. Yes, household members are defined in this chapter, and I will read the definition of household members, which household members means persons who, it's like a game, like where to stand here, for any period of time are living or have lived together, are sharing or have shared occupancy of a dwelling, are engaged in or have engaged in a sexual relationship, or minors or adults who are dating or have dated. Dating means a social relationship of a romantic nature.
Okay. Thank you, Madam Speaker. That more than responds to clearly we don't need cross-reference since it's already in other parts of the statute. My second question goes to on page 29, section 1182, where it actually seems to me, there may be a drafting reason that the member can explain, but it seems to me that there's a definition within a definition in a sense. Because A states that the party may request from the court an order restricting abusive litigation if, and it lists all the way through under subsection 1 and 2, these criteria that the party has to make. But those are the identical criteria that are already part of the very definition of abusive litigation. So I'm wondering why that definition would be repeated when abusive litigation by definition already includes that entire definition.
Madam Speaker, my recollection is in testimony and in discussion that we wanted to be incredibly deliberate in making sure we had belts and suspenders in place to narrow who this included. Again, balancing that due process constitutional rights and really making sure there's no, it seemed better to err on the side of being repetitive than leave any doubt.
Thank you, Madam Speaker. Just one other question. In the section 1185, beginning at the bottom of page 31, begins a series of different kinds of steps, and most of them refer to a judicial officer. Prior to that in the bill, all the references are to the court, and actually under all of these, it's all judicial officer except one spot where it uses the term the judge instead. And I'm wondering if the member could just clarify what individuals in the court system come under the term judicial officer in contrast to the term the court or the term the judge.
I am going to confirm this before third reading, but I believe we have magistrates that are conducting hearings. Certainly they're doing relief from abuse orders. So I believe that judicial officer is magistrate and a judge, but I will absolutely confirm that and report back in.
I would appreciate that, Madam Speaker, for confirmation, but also at the same time, maybe checking. I know that there are some individuals who function in the court system in judicial roles, and it may not be a magistrate, it may be the side judges, but who are not required to be attorneys. So it's not really the same as the criteria that a judge would meet. I don't know where magistrates fall in that, but I think it'd be important to understand whether it's the appropriate level of decision maker for deciding whether a person would be restricted from filing a lawsuit or not. So, Madam Speaker, I appreciate that we'll hear back on that before third reading.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Members, that completes the orders of the day. Are there any announcements? Seeing none? Oh, member from Hartford.
Madam Speaker, the Social Equity Caucus will be meeting tomorrow at 4:30. It will be virtual, and if anybody does need a space to join us, they can join us in room 30. Thank you.
Are there any further announcements? Member from Chittenden.
Madam Speaker, when I woke up this morning, I realized it was February, which means March is right around the corner. And for those of you that are interested, and I hope many of you are, we will have a little March Madness competition once again. The senior member from Winooski did this chamber proud last year. coming in second place. Almost first, but lost out at the end to our new Attorney General. So it's a lot of fun. You don't have to know a lot about basketball, but I hope you will all participate. And by the time March comes around, you'll probably be tired of me sending you reminders. Thank you, Madam Speaker.
Are there any further announcements? Member from Putney.
Thank you, Madam Speaker. I want to thank the member for reminding us, and it seems to me he does such a good job on what is sports betting that maybe we should bring him in to help us get going with the bill that we're working on in House Government.
Are there any further announcements? Members, are there any further announcements? Seeing none, member from Poultney, can you please offer us a motion to adjourn until Thursday, February 2nd at 3 p.m.?
Madam Speaker, I make a motion this body stand in adjournment until Thursday, February 2nd, 2023 at 3 p.m.
You have heard the motion. Are you ready for the question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and this body stands in adjournment until tomorrow at 3 p.m.